Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. This episode will cover Book 1, Pre-Employment, from Articles 12 to 24. Article 12. Statement of Objectives. It is the policy of the state to promote and maintain a state of full employment through improved manpower training, allocation and utilization, to protect every citizen desiring to work locally or overseas by securing for him the best possible terms and conditions of employment, to facilitate a free choice of available employment by persons seeking work in conformity with the national interest, to facilitate and regulate the movement of workers in conformity with the national interest, to regulate the employment of aliens, including the establishment of a registration and our work permit system, to strengthen the network of public employment offices and rationalize the participation of the private sector in the recruitment and placement of workers, locally and overseas, to serve national development objectives, to ensure careful selection of Filipino workers for overseas employment in order to protect the good name of the Philippines abroad. Title 1. Recruitment and Placement of Workers. Chapter 1. General Provisions. Article 13. Definitions. Worker means any member of the labor force, whether employed or unemployed. Recruitment and placement refers to any act of canvassing, enlisting, contracting, transporting, utilizing, hiring or procuring workers, and includes referrals, contract services, promising or advertising for employment, locally or abroad, whether for profit or not, provided that any person or entity which, in any manner, offers or promises for a fee, employment to two or more persons, shall be deemed engaged in recruitment and placement. Private fee-charging employment agency means any person or entity engaged in recruitment and placement of workers for a fee which is charged, directly or indirectly, from the workers or employers, or both. License means a document issued by the Department of Labor authorizing a person or entity to operate a private employment agency. Private recruitment entity means any person or association engaged in the recruitment and placement of workers, locally or overseas, without charging, directly or indirectly, any fee from the workers or employers. Authority means a document issued by the Department of Labor authorizing a person or association to engage in recruitment and placement activities as a private recruitment entity. Seaman means any person employed in a vessel engaged in maritime navigation. Overseas employment means employment of a worker outside the Philippines. Immigrant means any person, worker or otherwise, who emigrates to a foreign country by virtue of an immigrant visa or resident permit, or its equivalent in the country of destination. Article 14. Employment Promotion. The Secretary of Labor shall have the power and authority to organize and establish new employment offices, in addition to the existing employment offices, under the Department of Labor as the need arises, to organize and establish a nationwide job clearance and information system, to inform applicants registering with a particular employment office of job opportunities in other parts of the country, as well as job opportunities abroad, to develop and organize a program that will facilitate occupational, industrial, and geographical mobility of labor and provide assistance in the relocation of workers from one area to another, and to require any person, establishment, organization, or institution to submit such employment information as may be prescribed by the Secretary of Labor. Article 15. Bureau of Employment Services. The Bureau of Employment Services shall be primarily responsible for developing and monitoring a comprehensive employment program. It shall have the power and duty to formulate and develop plans and programs to implement the employment promotion objectives of this title, to establish and maintain a registration and/or licensing system, to regulate private sector participation in the recruitment and placement of workers, locally and overseas, and to secure the best possible terms and conditions of employment for Filipino contract workers, in compliance therewith under such rules and regulations as may be issued by the Minister of Labor, to formulate and develop employment programs designed to benefit disadvantaged groups and communities, to establish and maintain a registration and/or work permit system to regulate the employment of aliens, to develop a labor market information system in aid of proper manpower and development planning, to develop a responsive vocational guidance and testing system in aid of proper human resources allocation, and to maintain a central registry of skills, except seamen. The regional offices of the Ministry of Labor shall have the original and exclusive jurisdiction over all matters or cases involving employer-employee relations, including money claims arising out of or by virtue of any law or contracts involving Filipino workers for overseas employment except seamen, provided that the Bureau of Employment Services may, in the case of the National Capital Region, exercise such power whenever the Minister of Labor deems it appropriate. The decisions of the regional offices of the Bureau of Employment Services, if so authorized by the Minister of Labor as provided in this article, shall be appealable to the National Labor Relations Commission, upon the same grounds provided in Article 223 hereof. The decisions of the National Labor Relations Commission shall be final and inappealable. The Minister of Labor shall have the power to impose and collect fees based on rates recommended by the Bureau of Employment Services. Such fees shall be deposited in the National Treasury as a special account of the General Fund for the promotion of the objectives of the Bureau of Employment Services, subject to the provisions of Section 40 of Presidential Decree No. 1177. Article 16. Private recruitment. Except as provided in Chapter 2 of this title, no person or entity other than the public employment offices shall engage in the recruitment and placement of workers. Article 17. Overseas Employment Development Board. An Overseas Employment Development Board is hereby created to undertake, in cooperation with relevant entities and agencies, a systematic program for overseas employment of Filipino workers in excess of domestic needs and to protect their rights to fair and equitable employment practices. It shall have the power and duty to promote the overseas employment of Filipino workers through a comprehensive market promotion and development program, to secure the best possible terms and conditions of employment of Filipino contract workers on a government-to-government basis, and to ensure compliance therewith, to recruit and place workers for overseas employment on a government-to-government arrangement, and in such other sectors as policy may dictate, and to act as Secretariat for the Board of Trustees of the Welfare and Training Fund for Overseas Workers. Article 18. Ban on direct hiring. No employer may hire a Filipino worker for overseas employment, except through the boards and entities authorized by the Secretary of Labor. Direct hiring by members of the Diplomatic Corps, international organizations, and such other employers as may be allowed by the Secretary of Labor is exempted from this provision. Article 19. Office of Immigrant Affairs. Pursuant to the national policy to maintain close ties with Filipino migrant communities and promote their welfare as well as establish a data bank in aid of national manpower policy formulation. An Office of Immigrant Affairs is hereby created in the Department of Labor. The office shall be a unit at the office of the Secretary and shall initially be manned and operated by such personnel and through such funding as are available within the department and its attached agencies. Thereafter, its appropriation shall be made part of the regular General Appropriations Decree. The office shall, among others, promote the well-being of immigrants and maintain their close link to the homeland by serving as a liaison with migrant communities, provision of welfare and cultural services, promote and facilitate reintegration of migrants into the national mainstream, promote economic, political and cultural ties with the communities, and generally to undertake such activities as may be appropriate to enhance such cooperative links. Article 20. National Seaman Board. A National Seaman Board is hereby created, which shall develop and maintain a comprehensive program for Filipino seamen employed overseas. It shall have the power and duty to provide free placement services for seamen, to regulate and supervise the activities of agents or representatives of shipping companies in the hiring of seamen for overseas employment, and secure the best possible terms of employment for contract seaman workers, and secure compliance therewith. To maintain a complete registry of all Filipino seamen, the board shall have original and exclusive jurisdiction over all matters or cases including money claims involving employer-employee relations arising out of or by virtue of any law or contracts involving Filipino seamen for overseas employment. The decisions of the board shall be appealable to the National Labor Relations Commission upon the same grounds provided in Article 223 hereof. The decisions of the National Labor Relations Commission shall be final and inappealable. Article 21. Foreign Service Role and Participation. To provide ample protection to Filipino workers abroad, the labor attaches, the labor reporting officers, duly designated by the Secretary of Labor, and the Philippine diplomatic or consular officials concerned, shall even without prior instruction or advice from the Home Office, exercise the power and duty to provide all Filipino workers within their jurisdiction assistance on all matters arising out of employment, to ensure that Filipino workers are not exploited or discriminated against, to verify and certify, as requisite to authentication, that the terms and conditions of employment and contracts involving Filipino workers are in accordance with the Labor Code and rules and regulations of the Overseas Employment Development Board and National Seaman Board, to make continuing studies or researches and recommendations on the various aspects of the employment market within their jurisdiction, to gather and analyze information on the employment situation and its probable trends, and to make such information available, and to perform such other duties as may be required of them from time to time. Article 22. Mandatory remittance of foreign exchange earnings. It shall be mandatory for all Filipino workers abroad to remit a portion of their foreign exchange earnings to their families, dependents, and or beneficiaries in the country, in accordance with rules and regulations prescribed by the Secretary of Labor. Article 23. Composition of the boards. The OEDB shall be composed of the Secretary of Labor and Employment as chairman, the Undersecretary of Labor as vice chairman, and a representative each of the Department of Foreign Affairs, the Department of National Defense, the Central Bank, the Department of Education, Culture, and Sports, the National Manpower and Youth Council, the Bureau of Employment Services, a workers' organization, and an employers' organization, and the Executive Director of the OEDB as members. The National Seaman Board shall be composed of the Secretary of Labor and Employment as chairman, the Undersecretary of Labor as vice chairman, the Commandant of the Philippine Coast Guard, and a representative each of the Department of Foreign Affairs, the Department of Education, Culture, and Sports, the Central Bank, the Maritime Industry Authority, the Bureau of Employment Services, and National Shipping Association, and the Executive Director of the NSB as members. The members of the board shall receive allowances, to be determined by the board, which shall not be more than 2,000 pesos per month. The board shall be attached to the Department of Labor for policy and program coordination. They shall each be assisted by a secretariat, headed by an executive director, who shall be a Filipino citizen, with sufficient experience in manpower administration, including overseas employment activities. The executive director shall be appointed by the President of the Philippines, upon the recommendation of the Secretary of Labor, and shall receive an annual salary as fixed by law. The Secretary of Labor shall appoint the other members of the Secretariat. The Auditor General shall appoint his representative to the boards, to audit their respective accounts, in accordance with auditing laws and pertinent rules and regulations. Article 24. Boards to issue rules and collect fees. The boards shall issue appropriate rules and regulations to carry out their functions. They shall have the power to impose and collect fees from employers concerned, which shall be deposited in the respective accounts of said boards, and be used by them exclusively to promote their objectives. And that is the end. If this audiobook has helped you, please comment down below, and like and share our video to someone who might need it. For more Study With Me sessions, please subscribe to our channel. Thank you so much for making us your law school buddy.